Hi guys, this is Navdeep Singh Jitla. Thank you for clicking the channel. Today we are talking about a new case here. This is an application for study permit. It got refused, and the applicant name is Miss Güniz Fidan Peniz. Is a citizen of Turkey who holds a degree in tourism. In November 2016, she applied to a Capilano University in Vancouver, British Columbia, to study tourism management for international students. So please keep a note that she is already having a degree in tourism. All right. She was accepted into a program and paid 5,000 Canadian dollars as tuition fee deposit. She then applied to Citizenship and Immigration Canada (CIC) for a study permit. Ms. Peniz was meant to start classes in early January 2017, but her application for a study permit was refused in late December 2016 by an immigration officer at Canada Embassy in Ankara, Turkey. So the officer was not convinced that applicant was seeking to enter Canada for a sole purpose of studying and that she would leave Canada at the end of her stay. So the applicant reapplied for a study permit 2 days later, providing officer with an additional letter seeking out her intentions, but her application was again refused for the same reasons on January 4th, 2017. So as you can understand, she got the refusal letter, and after 2 days she tried to answer whatever the queries were raised in the refusal letter and submitted another application with an additional letter, but the application was again refused on the same grounds, which means that she might have repeated the same mistake. As I always tout that you must apply for GCMS notes to get to the bottom of the things before reapplying for the study permit, because you need to know the exact reason why visa officer refused the application. Otherwise you might be repeating the same mistake again as she did. Ms. Pins has filed an application for judicial review of the officer's decision. She argues that the decision is unreasonable because it was based on findings of the fact unsupported by the evidence. So she's saying that the visa officer's decision was unreasonable because there was no evidence or there was no corroborating proof what visa officer is saying. So she claims that the officer ignored and failed to consider relevant evidence, notably her statement that she intended to go back to her country of origin after her studies. So she further submits that the officer breached his duty of procedural fairness by failing to send a procedural fairness letter and to allow her to respond to his concerns. She asks this court to quash the decision and to send it back for the redetermination by a different immigration officer. Let's study some background of this case. The officer's decision is brief and takes a form of standardized letter used by CSE, where visa officers simply check in relevant boxes. According to a decision, the applicant was denied a study permit due to this section on the basis that she did not satisfy the officer that she would leave Canada at the end of her stay. So to reach the decision, the applicant would not leave Canada. The officer checked off one single factor on the standard form used by CAC, namely the purpose of visit. None of the other factors under the heading "not satisfied that you would leave Canada at the end of your stay" was checked by the officer, such as family ties in Canada or in the country of residence, employment prospects in the country of residence, current employment situation. So in the decision, the officer, however, identified other reasons in support of this decision, stated that Ms. Applicant's proposed studies were not in light or not reasonable. Studies were not reasonable in light of her qualification, previous studies, employment level of establishment, other education opportunities available to her or her future prospects and plans. So this is a standard reason, as we all understand. Let's look at the GCMS notes. So here are the GCMS notes, as you can see right here. The application reviewed, previous refusal noted, 31-year-old. So the applicant is a 31-year-old. That's number one. So the applicant is 31-year-old. That's the first point to note. Married, Turkish national, traveling to Canada to study for a tourism diploma. Applicant graduated in 2008. So the previous education was 2008 with the bachelor degree in tourism. And she applied in 2016. So after 8 years. Okay. No explanation on why she is pursuing studies at a lower level than she has already obtained. As you might have noted, she was graduated in 2008 with a bachelor degree in tourism, and now she's applying for an international diploma, which is obviously of a lower level than a degree. So it didn't make sense to the visa officer, It's apparent here. No explanation on why she is pursuing study at a lower level than what she has already obtained. Appears to have unemployed from 2008 until 2014. So she might not have submitted any full-time employment evidence and has been holding irregular employment since 2014. So she was not full-time. So she was not working full-time anywhere, it seems like, based on the documents. Purpose doesn't appear to me reasonable in context of applicant's background. Now, this is the key here. This is the crux that visa officer. Now this is the crux which visa officer formed after looking at the factors. Purpose doesn't appear to be reasonable based on the age, based on the previous education. The purpose of studying that particular program does not make any sense. It is not appear to be reasonable in context of applicant's background. Not satisfied that applicant is a genuine student, she would not leave Canada after the end of her stay. She probably had applied for this program because I presume she might have tried for Express Entry also or some other programs also, but she might not be able to score good enough in English or maybe due to some other factors also, because it is, even if we check her eligibility as per Express Entry, she's having bachelor's degree, her age is 31, and she was not having any experience. That is one for Express Entry. She might have tried for the Express Entry, but it probably didn't work. Then she had tried with this one. It doesn't make sense to me. After having a graduation, bachelor degree in tourism, you're applying for a lower level of education, or it is also possible that she was not even aware of this Canadian education system. So after looking at the various factors, the visa officer refused her application, and I presume that you also are getting some insight to the visa officer's understanding about the cases and the factors which visa officers use to evaluate an application. Because this was in judicial review, the decision of the visa officer was challenged, because what visa officer said, he was not satisfied based on the evidences or whatever. So after all this analysis, the federal judge allowed this application to be redetermined by the different visa officer, and the decision of approval will be subject to the new officer analysis. Thank you so much. I hope you have learned something from this application, and I'll see you in the next video.